Right. Is this on? It's on television.
Judgment in the appeal, Secretary of State for the Home Department against AP.
I shall ask Lord Brown to deliver this judgment.
The appellant is an Ethiopian national who was the subject of a control order. The control order, made in January 2008, subjected AP to, amongst other things, a 16-hour curfew. This control order at first required AP to live at an address in North London. AP's family, friends and associates had always lived in the London area. In April 2008, the Secretary of State modified the terms of the control order, requiring AP to move to an address in a Midlands town some 150 miles away. It was this modification that led to AP's appeal. The High Court allowed AP's appeal against the modification, quashing the obligation to live in the Midlands. It rejected AP's case under Article 8 of the European Convention on Human Rights on the ground that the interference with his family life was justified and proportionate in the interests of national security, but decided that the overall effect of a 16-hour curfew and AP's social isolation, particularly through his being separated from his family, constituted an Article 5 deprivation of liberty. The Court of Appeal, by a majority, reversed the decision of the High Court. AP appealed. The three issues for the Supreme Court's decision on this appeal are as follows. One, whether the conditions which are proportionate restrictions upon Article 8 rights can tip the balance in relation to Article 5, i.e. whether they can be taken into account in holding that a control order is a deprivation of liberty when, absent those restrictions, it would not have been held to be such. Two, whether the judge can take into account subjective and or person-specific factors, such as the particular difficulties of the subject's family in visiting him in a particular location when considering whether or not a control order amounts to a deprivation of liberty. Three, whether it was permissible for the Court of Appeal to interfere with the first instance judgment on the ground that the judge had relied on findings of fact in respect of Article 5, which were inconsistent with his findings of fact in respect of Article 8. In relation to the first issue, the Court considers the answer is an obvious yes. If an Article 8 restriction is a relevant consideration in determining whether a control order breaches Article 5, then by definition it's capable of being a decisive factor, capable of tipping the balance. The weight to be given to a relevant consideration is, of course, always a question of fact and entirely a matter for the decision maker, subject only to a challenge for irrationality, which neither has nor could have been advanced in this case. The Court is of the view the Secretary of State was wrong to contend that in assessing the weight to be given to the restrictive effects of a condition such as that imposed on AP here to reside in the Midlands, the judge should ignore everything that depends on the individual circumstances of the family. Plainly, AP's family could not be allowed to thwart what would otherwise be an appropriate residential requirement by unreasonably failing to take opportunities open to them to visit AP and save him from social isolation. It's not suggested by the Secretary of State that AP's family behaved unreasonably in failing to overcome more effectively the practical difficulties they faced in visiting AP on a more regular basis, only that their particular difficulties should have been ignored. That submission cannot be accepted. In relation to the third issue, having considered the relevant parts of the High Court's judgment, the Court considers that there is no contradiction between them. The Supreme Court unanimously allows the appeal, sets aside the decision of the Court of Appeal, and restores the High Court's order.
Judgment in the appeal, MS Palestinian Territories against the Secretary of State for the Home Department.
I shall ask Sir John Dyson to deliver this judgment.
The appellant was born in Gaza in 1985. Having lived in Libya until about 2002, he then spent time in mainland Europe before arriving in the United Kingdom in April 2007. He subsequently claimed asylum and humanitarian protection. On the 24th May 2007, the Home Secretary refused the appellant's asylum and human rights claims. The letter sent by the Home Secretary recorded that a decision had been taken to remove the appellant from the United Kingdom and stated, quote, "If you do not appeal or you appeal and the appeal is unsuccessful, you must leave the United Kingdom. If you do not leave voluntarily, the directions will be given for your removal from the United Kingdom to Palestine National Authority," end of quote. The appellant appealed the decision under Section 82(2)(h) of the Nationality, Immigration and Asylum Act 2002, the 2002 Act. He did so on the grounds that the decision was, quote, not in accordance with the law, unquote, within the meaning of Section 84(1)(e) of the 2002 Act, because directions for his removal to the Palestine territories could not lawfully be given under Schedule 2 of the Immigration Act 1971, the 1971 Act, since paragraph 8(1)(c) of Schedule 2 required that there was reason to believe that he would be admitted to the country chosen. The immigration judge accepted the evidence given in support of the appellant that, owing to his lack of documents and the fact that he did not have any living parents, he would not be admitted to the Palestinian territories. However, the immigration judge rejected the appellant's argument that this meant that the decision was, quote, not in accordance with the law, unquote, under Section 84 of the 2002 Act. The Immigration Tribunal and the Court of Appeal agreed with the immigration judge. The appellant appealed to the Supreme Court. The Supreme Court unanimously dismisses the appeal. It holds that there is no right of appeal against an immigration decision under Section 82(2)(h) of the 2002 Act, on the ground that the country or territory stated in the notice of the decision is not one that would satisfy the requirements of paragraph 8(1)(c) of Schedule 2 to the 1971 Act. The decision of the court is based on a detailed analysis of the language of sections 82 and 84 of the 2002 Act and various policy reasons identified in the judgment. Accordingly, the appeal is dismissed. The parties are to make written submissions on costs in the House of Lords and the Supreme Court by the 7th July 2010, and there is to be a detailed assessment of the appellant's publicly funded costs.